If you've been injured in an accident in Wisconsin, you probably have a lot of questions. You may be wondering, do I even have a case? How hard is it to win a personal injury claim? What is my case worth? How long is this going to take? What happens if I call a lawyer? What if I say the wrong thing? How much is this going to cost? And what actually happens if a lawsuit has to get filed? These are all completely normal questions. Most people in Wisconsin will never hire a personal injury lawyer in their lifetime. Most people who contact a personal injury lawyer have never done this before. So in this video, I want to walk you through the complete process in one place. We'll talk about what a Wisconsin personal injury claim is, what has to be proven, how cases are investigated, how attorney's fees work, how long cases usually take, what happens if a lawsuit is filed, and then I'll talk about my background, experience, and philosophy as a Wisconsin personal injury attorney. The goal here is not to give you legal advice about your specific case. The goal is to help you understand the process so that you can make an informed decision for yourself and your family. And of course, if you want advice about your specific situation, you should talk directly to a lawyer. My phone number is on the screen. Feel free to reach out at any time. Now, who is this video for? This video is for people or family members of people who have experienced a personal injury in Wisconsin as a result of someone else's fault. Now, let's start with personal injury. That simply means something that required medical care, caused time away from work, or created ongoing physical or financial stress. This might be a car crash, a truck crash, or maybe a farming injury. It could be a workplace injury, depending on the facts and circumstances. It might be an injury from slipping or tripping on an unsafe property. It could involve a dog bite, a fire, or exposure to a dangerous product or chemical. Second, it has to be because of someone else's fault, not your own fault, and not an act of nature or God. I'll talk more about that in a moment. Now, I want to start out and also say who this video is not for. You see, this video is not for people who haven't sustained a personal injury. It's not for people dealing only with property damage. It's not for medical malpractice cases. They're a different category of personal injury entirely. And it is not for people who were injured because of their own fault or because maybe of no one's fault. For example, hitting a deer, or maybe you fall asleep at the wheel and run off the road when there's no other negligent party involved. Those situations may involve insurance questions, they may involve injuries, but they don't necessarily create a personal injury case. So what is a personal injury claim? A personal injury claim arises when someone is injured and the injury was caused by another person's fault, usually negligence. In other words, someone acted carelessly and that carelessness caused you harm. Personal injury law is designed to do one basic thing. It assigns responsibility for injuries and provides a legal way for injured people to recover compensation for the losses that they've suffered. Those losses may include medical bills, lost income, damage to personal property, and the personal impact of the injury on that person's life. Now, not every accident automatically creates a legal claim. For a case to succeed, certain legal elements have to be proven. So how hard is it to win a personal injury case? Now, personal injury cases require proof. Insurance companies do not simply pay claims because someone was injured. To succeed in a claim, there must be evidence showing that someone else is legally responsible for causing the injury. Now, that evidence will generally include things like accident reports, medical records, photographs, witnesses, videos, and expert opinions. The difficulty of a case often depends on several things: how clear the fault is, how serious the injury is, and how well the evidence documents what happened. Whether there is insurance coverage is another huge factor, and sometimes it comes down to the credibility of the people involved. Now, I want to talk about third-party claims and workplace injuries. One area that often causes confusion is the relationship between workers' compensation and personal injury claims. In most workplace injuries, employees cannot sue their employer directly. Instead, the law provides workers' compensation benefits. Now, workers' compensation typically covers the medical care and a portion of lost wages, regardless of who caused the accident. The damages are limited. Now, the trade-off for providing coverage, regardless of fault, is that it limits the damages that can be recovered against the employer. We often call this the exclusive remedy rule. It generally applies to injuries caused at work, even if by a co-employee. But there is an important exception. If someone other than the employer or another employee caused the injury, a separate personal injury claim may still exist. We call those third-party claims. Now, for example, imagine you're a truck driver who was injured by another motorist during the course of employment. Or maybe a delivery driver is injured when they trip or fall at another business location. Or maybe a farm worker gets injured by defective machinery or is exposed to dangerous chemicals. In those situations, there may be two claims happening at the same time: workers' compensation benefits through the employer and a civil injury claim against the negligent third party. That civil claim may allow recovery for damages that workers' compensation simply doesn't cover. Now, understanding who is responsible is a key part of these cases. Now, to win a personal injury case, a plaintiff must generally prove negligence. In simple terms, negligence usually requires four things. First, a duty of care to someone. Second, someone acted carelessly or unreasonably. Third, that carelessness actually caused the accident. And fourth, that accident caused real damages. Lawyers often describe this as duty, breach, causation, and damages. But the core idea is the same. Someone's carelessness caused someone's harm. A simple example might be a driver who runs a red light and causes a crash. Running the red light is the negligent act. The collision is what the act caused. And the injuries and damages are the result. But even when someone is injured, there still must be proof. Sometimes injuries occur from accidents, but there is no legal case. For example, imagine someone falls asleep while driving and runs off the road, or another driver unexpectedly has a medical emergency and crosses the center line. If no other driver or entity contributed to the crash, there may be no defendant to sue. You generally can't sue yourself for your own fault. Or consider maybe a driver who collides with a deer on a rural highway. That may cause serious injuries, but generally there's no negligent party responsible for the deer entering the roadway. Now, we can distinguish that from a situation, let's say, where cattle escape from a fence. They wander onto the road and then cause an accident. Depending on the facts, there may be a case against the farmer or whoever allowed the cattle to escape. There are other examples too. A mechanical failure that could not reasonably have been discovered, natural conditions like ice forming immediately after a storm and before the property owner could reasonably respond to it. These events can be serious and tragic, but personal injury law requires negligence. It requires fault. Without negligence, there may not be a case. Now, for many people, calling a lawyer for the first time can feel intimidating. You may be wondering, what am I supposed to say? What if I leave something important out? Are they going to start using legal terms that I don't understand? Am I going to be pressured to file a lawsuit right away? How much is it going to cost? These are very normal questions. Now, the first step is usually an initial consultation. In personal injury cases, that consultation is almost always free. And you could talk to multiple lawyers before deciding who's the right fit for you. Your consultation with a lawyer's office should be confidential. That means they should not share what you talk about with anyone else. If you're unsure, just ask whether the call is confidential. Now, during that conversation, the lawyer or someone at their office is going to ask you to describe what happened and gather some basic information for them. Typical topics in that initial consultation will include like when and where the accident happened, who may have been involved, what injuries, if you know, were sustained, what kind of medical treatment have you received so far, and have you spoken with any insurance companies? As you describe what happened, the lawyer may have some follow-up questions to better understand the details. For example, where exactly did the accident occur? What county, city, intersection, or travel lane was involved? Was law enforcement called to the scene, and which one? Was it police, sheriff, or highway patrol? Did you receive medical care the same day, or did you come back later? Do you know who owns the vehicle or the equipment involved? Have you spoken with an insurance adjuster? Did you give a recorded statement? Were you already dealing with injuries or health conditions that may have been aggravated by this accident? These questions are not meant to embarrass you or put you on the spot. They're there to help the lawyer understand the facts as soon as possible. Now, one of the first things a lawyer or law firm will do is try to find out who are the people involved, including other drivers and insurance companies. Now, one reason for that is to check for any conflicts of interest. You see, law firms and lawyers have ethical obligations that prevent us from representing both sides of the same dispute, or sometimes even one party if they already represent another party involved in an unrelated matter. For example, maybe the other driver is going through a divorce and is represented by another lawyer in that law firm. Now, most of the time there is no conflict, but if there is, the lawyer might be able to help point you in the right direction towards someone who can help. Now, that initial consultation really has two main goals. First, it helps the lawyer understand what happened so they can decide whether they can even help you. And second, it helps you decide whether you want that lawyer or that law firm to represent you. If you have documents like crash reports, any photos, insurance information, maybe medical bills or medical records, those can also be helpful at that initial consultation. But you don't have to have everything organized before making the call. The consultation is simply a conversation. Now, if you prefer to meet in person or by Zoom or another video platform, that lawyer should be able to accommodate that. Just try to make sure that that first consultation happens at a time and in a setting that is comfortable for you or your family. Don't feel pressured to sign a contract while you're still on the phone. Take the time to make sure the lawyer and the law firm are the right fit for you. Now, one of the biggest questions people have is pretty simple. How much does it cost to hire a personal injury lawyer? Most personal injury lawyers in Wisconsin work on what is called a contingency fee. That means you generally don't pay the attorney fees up front. Instead, the lawyer is paid a percentage of whatever the recovery is. If there is no recovery, the lawyer usually does not recover a fee. Now, what is a recovery? A recovery is the money that is obtained as compensation for the injury. That may come from an insurance settlement, a negotiated resolution, or a trial verdict. Sometimes it's multiple insurance policies. Recovery may include compensation for your medical expenses, lost income, future medical care, your reduced earning capacity, pain, suffering, disability, and other types of damages. Now, there are some key features of a contingency fee agreement. The lawyer receives a percentage of the recovery if the case is successful. And if there is no recovery, there generally isn't an attorney's fee. This allows people to pursue legitimate injury claims without paying legal fees out of pocket while they're still dealing with medical bills and lost income. You should be given a written fee agreement to review and sign. That agreement should clearly set out the fee arrangement and the terms. In many personal injury cases, percentage is generally somewhere between 33 and 45%, although each case may vary one way or the other. Now, sometimes that agreement works in stages. So if a case settles before a lawsuit, it may be one percentage. If it requires a trial or an appeal, that percentage may increase, and that should be laid out clearly in that written fee agreement. Now, I want to distinguish between attorney's fees and case expenses. Attorney's fees are the percentage paid for that legal representation. Case expenses are those actual out-of-pocket costs required to develop and pursue the case for the client. Now, examples of case expenses might include charges for obtaining medical records, court filing fees, expert witness retainers, deposition transcripts. Now, in most cases, the lawyer will advance those costs during the case, and then they get reimbursed out of the recovery later. Every fee agreement should clearly explain how expenses are handled, and you should ask questions if you're confused, and make sure you're comfortable with the arrangement. Another concept that comes up is what we call liens. Lien is something that gives someone else an interest in a settlement or recovery. For example, hospital lien may exist for medical expenses. We may also have what's called subrogation lien. That's where another insurance company, such as your health insurer, they may have paid for some of your medical expenses, and then they're entitled to reimbursement out of your recovery if there is a recovery. And again, this should be clearly explained in your fee agreement. Now, some people worry about saying the wrong thing when they talk to a lawyer for the first time. The most important thing is simply to be honest. You don't need to remember every detail perfectly. You don't need to know who was legally at fault. You don't need to know what the case might be worth. But it's important not to hide things like prior injuries, prior accidents or claims, or any any conversations you may have had with insurance companies or adjusters. Lawyers can work with difficult facts, but what causes problems later are surprise facts. Now, once a lawyer is hired, that law firm generally begins evaluating and investigating your case. This includes gathering medical records, medical bills, police and crash reports, insurance information, photographs or videos, employment records, and any other documentation that's relevant to the case. One of the early steps may be sending preservation letters to make sure important evidence is not lost or destroyed. Depending on the case, that could include vehicle data, maintenance records, accident reports, or electronic records. Lawyers may look for other sources of information as well. For example, if there was a business such as a gas station or a bank near an accident scene, sometimes they'll have security cameras that may have actually captured the accident. If that footage exists, it may need to be requested very quickly before it gets deleted. You see, a lot of camera systems overwrite old footage within weeks if no one requests that it be preserved. Now, once the representation begins, the lawyer will typically notify the insurance companies involved. That insurance company is told that a claim is being made and that all communication should now go through the lawyer rather than through the client. That helps protects clients from unnecessary pressure and from confusing or one-sided conversations with insurance adjusters. Now, one of the more important jobs the lawyer does is identify all potential insurance companies and policies that may provide coverage. If injuries are severe, it may take multiple policies to provide full compensation for serious injuries. Now, one of the other things that happens in that early evaluations is identifying important legal deadlines. That includes the statute of limitations, which is simply the deadline for bringing a lawsuit or other legal case. In Wisconsin, that deadline is typically 3 years from the date of the injury, but different rules may apply depending on the facts. That is one of the reasons it's really important to talk to a lawyer as soon as you reasonably can. Now, once the legal process begins, your main focus will be on medical treatment and recovering. However, there are a few important things you can do to help your case move along more smoothly. Probably most important is continuing to follow your doctor's treatment recommendations. You want to keep your lawyer informed if anything changes. That might mean, for example, maybe you see you get new treatment, or you start seeing a new specialist, or your work situation changes. If you miss more time from work, or you return to work with restrictions. These kinds of updates can help your lawyer understand how the injury is affecting your health and your livelihood, and help them try to assess what's the potential value of your claim. You may also be asked to provide documents such as medical bills, insurance letters, or employment records. Now, clients are generally advised to avoid discussing the case publicly or on social media. Insurance companies sometimes monitor public posts, and comments taken out of context can create confusion about the injury. Be sure to talk to your lawyer, however, before deleting any posts that already exist. Now, when people think about injury claims, they often assume there's only one insurance policy involved. In reality, there may be several types of coverage available. The most obvious is typically liability insurance. That's the insurance carried by the person who's responsible for causing the accident. Liability insurance may cover medical expenses, lost wages, and other damages caused by the negligent party. Now, property damage coverage may apply to damage to vehicles, equipment, or personal property. Now, these property claims are often resolved much earlier than injury claims because the damages can usually be sorted out rather quickly. There may also be medical payments coverage. We often call that MedPay. MedPay simply covers certain medical bills early on in the case, regardless of fault, and it's usually kind of a limited amount. This coverage typically comes from the injured person's own auto insurance policy. Now, health insurance may also pay medical bills while the case is pending, and when health insurance pays accident-related medical expenses, that insurance company generally has a right to reimbursement from any settlement or recovery. We call that subrogation. Now, these reimbursement issues are usually addressed once the case resolves. Now, what is a personal injury case worth? When negligence and causation can be proven, the next question people often ask is, what is my case worth? Damages in personal injury claims usually fall into two main categories: economic damages and non-economic damages. So let's talk about economic damages. Economic damages are the financial losses caused by the injury or the accident. These are often documented with records and bills, things like medical expenses, hospital treatment, therapy and rehab, prescription medications, lost wages, future medical care, property damage such as damage to your vehicle, equipment, or maybe rental costs for getting a replacement. Now, non-economic damages are the other category, and they reflect sort of the human impact of the accident and injury. Their losses are real, but they don't come from a receipt or a bill. That includes things like pain and suffering, disability or impairment, emotional distress, disfigurement, and loss of enjoyment of life. Wisconsin law also recognizes something called loss of spousal consortium if you were married at the time of the accident. Now, that refers to the loss of companionship, support, and marital relationship that can occur when one spouse suffers a serious injury. Now, I want to talk about wrongful death claims. In tragic situations where injuries result in death, Wisconsin law allows certain family members to bring a wrongful death claim, such as the surviving spouse or minor children. Those claims may include damages such as medical expenses, funeral and burial expenses, loss of financial support, loss of society and companionship. Now, Wisconsin unfortunately places statutory limits on some wrongful death damages, and the structure of those claims can depend on the surviving family members and the facts of the case. Now, most people who contact a lawyer will eventually ask a question such as, how long is this going to take? That's a very reasonable question if you haven't been through this before. If you've been injured, your life already feels disrupted. You may be missing work, going to treatment, dealing with insurance companies, and you just don't want this hanging over your head forever, especially once you're done treating. Now, here's the lawyer answer. It all depends. But here's sort of the simple answer. It's however long it takes you to fully heal from your injuries, or however long it takes doctors to determine that you've reached maximum medical improvement. Wisconsin personal injury cases tend to move in phases. There's generally four distinct stages or phases of a personal injury case. Number one is medical treatment and stabilization. Second is investigation and case development. Third is negotiation with the insurance company. And fourth, if necessary, is a lawsuit. Now, not every case reaches that fourth phase, but understanding all four will help you understand what controls the clock and how quickly things move along. So let's talk about phase one, medical treatment and stabilization. This is typically the longest part of the case. Before a claim can be fairly resolved, we need to understand your diagnosis, what kind of treatment you had and what treatment you might require in the future. Is surgery going to be required? Is there any permanent impairment, and will there be future treatment? If you try to resolve a case too early, before your condition stabilizes, you really risk leaving money on the table. In personal injury law, we often talk about maximum medical improvement, or MMI. That simply means that your condition has stabilized enough that doctors can reasonably evaluate the long-term future impact. Until that happens, it's often premature and just risky to settle your claim. The timeline is driven not so much by lawyers or courts, but by your own body and your medical treatment, however long that takes. Now, the second stage is the investigation part of the case. While your treatment is ongoing, your legal team was developing the case and the facts. They're gathering medical records, getting your medical information and documenting that, reviewing police reports, photos, videos, analyzing insurance policies, terms and conditions, calculating your wage loss, talking to doctors, obtaining reports from doctors or maybe experts, and just consulting with experts such as accident reconstructionists. Now, if liability is clear and injuries are pretty straightforward, this phase may move pretty quickly. However, if fault is disputed, if multiple parties are involved, or if the insurance coverage is complicated, unfortunately it can take a lot longer. The goal of this phase is not to be quick. The goal is to be accurate and to be prepared and to make sure we know exactly what we're doing. Now, phase 3 is negotiation. Now, once your medical condition has stabilized, either you've fully recovered or you've plateaued, we now have enough to understand the scope of your damages, and we can begin negotiating with the insurance company. That usually involves preparing a detailed demand package and then sending it to the responsible party's insurance company. That package summarizes your injuries, your treatment, your medical expenses, your wage loss, and talks about the overall impact of the injuries on your life. Now, the insurance company then reviews those materials. That can take some time depending on how much documentation is provided to them. You see, insurance carriers will have internal procedures, supervisors, sometimes they round table these claims. Some cases resolve during this phase, while others require multiple rounds of negotiations. Now, most cases are not seriously evaluated until the medical picture becomes very clear. If you fully recover, that case is often evaluated for resolution about 3 months after recovery. That allows time to gather the final records and bills. Now, if your injuries don't fully resolve, doctors may determine that the patient has reached MMI. In many serious injury cases, it may take about a year after the accident to determine whether those injuries are permanent and whether any ongoing treatment is expected to help. Once the medical picture is clear, negotiations begin in earnest. Now, if a fair resolution can't be reached through negotiation, that brings us to the 4th stage, where a lawsuit may be filed. Now, filing a lawsuit does not mean you're going to trial immediately. Trial seldom happens less than a year after the lawsuit starts, and often it can take 2 years or even more before a case actually reaches trial. Now, filing a lawsuit simply moves your claim into the official court system, where deadlines can be set and a judge is assigned to resolve any disputes. In Wisconsin, that process typically includes written disclosure of information and documents, depositions where parties and witnesses are questioned under oath, motions, mediation, and eventually a trial date. Trials often last anywhere from a couple days to maybe a few weeks, although most are completed in less than a week. Even after a lawsuit is filed, many cases still settle before trial. Now, what makes a case move faster? There are certain factors that can shorten the timeline. If there's clear liability, if the injuries are obvious, let's say broken bones or those requiring surgery, a clear and predictable medical outcome, maybe adequate insurance coverage or maybe inadequate insurance coverage. How cooperative are the parties and the lawyers? What slows a case down? Well, if the medical treatment is ongoing, if fault is disputed, if there are multiple parties involved, if there's insurance coverage that's limited, unclear, or maybe in dispute, that can really complicate things. And then there may be need for experts. Congested court calendars and structural realities of cases and lawsuits can simply slow the process down. This isn't necessarily a sign that anything's wrong with your case. Generally, the more serious the injuries, the more preparation that is required to get the case ready for meaningful resolution. Now, that brings us to the settlement phase. Now, once medical treatment has progressed enough to understand the nature of the injuries, the case may move into the settlement phase. At that point, the lawyer will prepare a demand package summarizing what happened, the injuries involved, and the damages being claimed. That information is sent to the insurance company to be evaluated. Even when a lawsuit is filed, most cases still resolve before a jury trial. A good personal injury lawyer prepares every case as though it may eventually be presented to a jury. When insurance companies see that a case has been investigated thoroughly and prepared seriously, it often leads to more meaningful settlement discussions. Now, if a lawsuit is started, there's typically 5 distinct parts of the lawsuit that I want to talk about. First, the filing and service of the summons and complaint. That's how the lawsuit gets started. Second, there's discovery, and that's basically where both parties exchange information, ask questions, and take depositions. Third is any pretrial motions and usually formal mediation. And fourth, if the case doesn't settle, there's going to be a trial. And fifth, and very rarely, an appeal if either party disagrees with the trial result. Many cases resolve during discovery or mediation long before trial happens. Now I want to talk a little bit about comparative fault. You see, Wisconsin uses a comparative fault rule. If an injured party is partially responsible for an accident, your damages will usually be reduced in proportion to that at fault. For example, if you're 30% at fault, your damages are simply reduced by 30%. However, if you're more than 50% responsible, your recovery may be entirely barred. If a case goes to trial, the jury will be asked to divide fault among all the responsible parties. Now that rule can have a major impact on how cases are evaluated and what insurance companies are willing to pay. Now communication is a very important of the process of representing people. This usually includes updates when important developments occur, honest evaluation of the case, and the availability to answer questions. Now, there may be periods when things seem very quiet on your case, such as when medical treatment is ongoing. That's normal. Your lawyer probably has a team helping them with your case. Other lawyers, paralegals, and legal assistants can often help answer questions and keep you updated even when the main attorney is not immediately available. You see, most cases go through phases, with some stages busier than others. When a case is preparing for trial, when a lawyer is preparing for trial, that case becomes the focus of all their attention. Now, when does it make sense to hire a lawyer? Legal representation can be helpful when injuries are serious, liability is disputed, multiple parties are involved, or insurance coverage is complicated. Now, not every minor accident requires a lawyer. Serious injuries, however, often benefit from careful legal evaluation. It's also important to know that you're free to speak with more than one attorney before deciding who to hire. Consultations in personal injury cases ought to be free. That allows injured people to ask questions, understand your options, and choose the attorney you feel most comfortable working with. Once you choose a lawyer, you will sign a written fee agreement, and in many cases that can be done electronically if you prefer. Now, if you're considering hiring a personal injury lawyer, it's completely reasonable to want to know who you're dealing with. When you hire a lawyer for a serious injury case, you're trusting that person with something really, really important. So let me tell you a little bit about my background, my experience, and how I approach injury cases. I was born on a small dairy farm in northeast Iowa. Later, my family moved to South Dakota, where we operated a large beef ranch. Today, I live on a small farm in western Wisconsin with my wife and our 9 children. Farm life teaches you certain things early on: hard work, resourcefulness, and that you do not work from 9 to 5. You work until the job is done, whether you feel like it or not. You learn that results just don't come from shortcuts. They come from preparation, consistency, and hard work. That background shaped how I think about legal work and how I approach cases and my clients. Now, law was not my first plan. I actually originally intended to become a priest, and I studied for that in Winona, Minnesota. Now, when I decided to leave that path, I still had a strong desire to help people and do work that mattered. A priest friend actually recommended law school to me, and that actually turned out to be some of the best advice I've ever been given. A personal injury law in particular gives me the opportunity to help people during some of the hardest times of their lives. It's not really about arguing, it's more about listening, preparing, understanding how facts fit together, and then presenting those facts clearly in a way that a judge or a jury can understand. I'm a civil trial attorney. That means I prepare each case as if it may ultimately be presented to a jury. Now, not every case goes to trial. In fact, most do not. But the possibility of trial helps shape how a case is prepared from the very beginning. Insurance adjusters can tell whether a lawyer is actually willing to take a case to trial or whether that lawyer will eventually cave. Knowing that your lawyer will take a case to trial when necessary is one of the biggest factors in getting maximum recovery for your claim. Over the years, I've handled a range of serious injury matters. The possibility of trial is always one of the most important sources of leverage against insurance companies. Now, my practice focuses on injury and civil litigation matters. That includes car accidents, commercial vehicle and trucking cases. I actually hold a Class A commercial driver's license, and I still drive truck when I get the chance. Farm-related injuries and other serious injury claims where liability and damages may be unusual or complex are part of the things that I do on a regular basis. Now, my approach in the courtroom is pretty straightforward. I prepare thoroughly from the beginning of the case to the end. I try to be honest and transparent with clients, judges, and even jurors. I try to present that evidence clearly, respect the intelligence of the jury, avoid exaggeration, and avoid pursuing claims that we simply can't win. Because of my background, I understand rural and working communities. I understand the realities of physical labor. I understand what it means when an injury affects your ability to work with your hands. I understand how difficult it can be to pay bills when you simply can't work. I understand the importance of being able to play with your kids and attend their activities. That influences how I communicate. It influences how I evaluate cases and how I prepare them. Now, I'm licensed in Wisconsin, Minnesota, and Iowa, in both state and federal courts. In western Wisconsin, southeast Minnesota, and northeast Iowa, people regularly travel across state lines for work, business, and just everyday life. That gives me flexibility in handling cases that involve multiple states and helps me choose the court system that best fits the particular case. When someone contacts my office, I try to listen and gather as much information as I can about their case and what really matters to them. I try to give my honest opinions, I don't sugarcoat, and I try to make sure clients understand their options so that they can make informed decisions for themselves. I want clients to believe that I'm the best lawyer for their case, and if I don't think I'm the best lawyer for them, I'll try to help them find someone who is. I'm not a volume-based operation. You probably won't see me on any billboards or at the gas pump. I'm not interested in quick settlements if they don't reflect the seriousness of the injury. I try to use my experience and my firm's resources to work every client's case to the best possible way. If you've made it this far, here is the big picture. A Wisconsin personal injury claim follows a simple process. It starts with figuring out whether negligence can be proven, then documenting the injuries and damages, then understanding the insurance coverage, then allowing enough time for medical recovery and for doctors to determine the long-term impact of those injuries. Then we negotiate seriously, and if necessary, we'll file a lawsuit and prepare that case for trial. At the same time, if you're considering hiring a lawyer, you should know that the first consultation should be free, the conversation should be confidential, and you're free to talk to more than one attorney before making a decision. You should understand how contingency fees work, how cases are handled, and what your lawyer's communication style and approach will be. Most of all, you should make sure the lawyer you hire is someone you trust to handle something very important to you. Because these cases are not just about paperwork, they're about your health, your work, your finances, and ultimately your future. If you're in that situation, take your time, get informed, ask questions, and then make the decision that is right for you and your family.